really struck by your comment in your opening remarks about how disheartening it is to see the Supreme Court of Canada strike down offenses related to the sexual exploitation of children like they did in Seneville based on reasonable hypotheticals. And while C-16 doesn't prohibit the courts from using hypotheticals in their reasoning, Section 63, the so-called safety valve, does make exceptions in some cases to sort of preserve and signal the importance of mandatory minimums for things like murder and treason. And so what I was wondering is whether or not including offenses related to sexual exploitation of children into Section 63, the safety valve, whether or not that might address your concerns.
We actually feel that the provision that's been added into C-16 is a reasoned response to the jurisprudence that exists. The reality is that we have the case law that we have on mandatory minimums. And from our perspective, since the Friesen decision was issued in 2020, sentencing when it involves offenses against children have improved considerably. And when we talk about edge cases, which is what the hypotheticals were really focused on, that's where you start to lose sight of what the harm actually is in the vast majority of the cases. And from our perspective, this safety valve should help to preserve the mandatory minimums for the vast majority of cases that actually do reach the courts in this country.
To dig into that a little bit, because I'm wondering how it does that, because it doesn't, if the reasonable, what I worry about is that the cases that would cause the safety valve to be used become the very hypotheticals that then allow the whole offense to be struck down. And so if you're getting out of edge cases, like if there's a case that's in front of the courts, then it's not an edge case. And how do you, I worry that they will also decide that there are edge cases as well, and that it might actually increase the probability that the law gets struck down. Do you see where I'm getting at?
Yes, but the safety valve is about sentencing. It's not about the offense itself. So that would be a different issue, challenging the offense and the constitutionality of the offense and what it covers, whereas the sentencing part is about what the sentence actually is going to be and whether or not a mandatory minimum is justifiable in the case of the specific offender that's before the courts and the specific offense that offender committed.
I don't think that you don't think that defense counsel will then use that to argue that the offense itself, because of the way that it was structured, you're not concerned that there's going to be additional litigation as a result of this?
I didn't say that. What I was talking about was the difference between sentencing and the offense itself. There's always going to be constitutional challenges to offenses, and we expect that will continue. But the safety valve provision is about preserving the mandatory sentences to the greatest extent possible in light of the jurisprudence we actually have.
Right, but it is the sentence, it is the mandatory minimum, it's the sentence that actually gets struck down in these circumstances, and we get into a bit of a circular loop, as you can see from the question itself. Are there amendments that you think would help under these circumstances? Like, are there amendments that would solve the circumstances that are causing the disheartenment?
So the safety valve will help in terms of reducing the amount of litigation that is then focused on hypothetical scenarios, because the safety valve itself is saying that when you're imposing something less than the mandatory minimum sentences, it's when that mandatory minimum sentence would be cruel or unusual as applied to that offender. Whereas the way that things were working prior to the safety valve is that the courts could come up with a hypothetical and then use that hypothetical offender that wasn't before the court and that offense being committed in that way that also wasn't before the court to say, well, in that circumstance, this offense would be, or this sentence, would be excessive. So what we do see is that the cases where the mandatory minimum sentence or where a court is imposing less than a mandatory minimum sentences it's not that often. And when it does happen, there are sort of some extenuating and exceptional circumstances that do exist.
Do you think that a 1-year mandatory minimum for child pornography is reasonable?
Very short answer.
Absolutely. We've always been supportive of the mandatory minimum sentences for child sexual abuse and exploitation material.
Thank you, Ms. Corliss. Okay.